So you've just got charged with a felony in California. Is there a way to get your case dismissed by diversion? We're going to try to answer that question and break it down in this video. Hi, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about the interplay of two different sections of the Penal Code. Penal Code Section 1001.95 and Penal Code Section 17B. Penal Code Section 17B allows a judge at a preliminary hearing to reduce a felony charge to a misdemeanor. Penal Code Section 1001.95, as you might know from our other videos, allows you to get what's called diversion if you're fighting a misdemeanor case, thereby allowing you to get your case dismissed without having to worry about what a jury of 12 people thinks about the strength of the government's case. So how do these two code sections interplay? Well, they work together in some situations to get your felony case dismissed if a charge of a felony is reduced from a felony to a misdemeanor and then granted diversion. Let's say you're accused of a felony offense. Some felony offenses are what we call wobblers under California law, meaning they could be prosecuted and punished as felonies or misdemeanors. Whether it would be a felony or a misdemeanor depends on the weighing of a lot of factors that prosecutors and then sometimes judges do. How severe is the offense? Does the defendant have any sort of prior record that is disturbing? Things like that are things that get considered. Prosecutors, for example, might be more likely to file an illegal gun possession charge as a felony if the gun is not registered, if it was used in a crime before, or if the defendant has a prior history. And judges might be more inclined to agree with prosecutors on those issues if those factors are present, depending on what comes forth at the preliminary hearing. So let's back up a little bit. Remember that when you're facing a felony charge, you have a right to something called a preliminary hearing. At that hearing, the prosecutor has to convince a judge that there's probable or sufficient cause that a crime has been committed and that you, the defendant, had committed it. They don't have to prove you guilty beyond a reasonable doubt. They have to prove there's probable cause. That's a pretty low burden to fulfill. However, the preliminary hearing can be useful in some cases where the defendant is facing what we call wobbler charges, because at that preliminary hearing, the defendant can use that to argue before the judge that you should reduce the charges down from felonies to misdemeanors, because the judge has the discretion to basically overrule the prosecutor on that issue. And that is where Section 17B comes in, because Penal Code Section 17B explicitly gives a judge hearing a preliminary hearing to exercise the discretion and say, hey, even if you find that the defendant had actually, that there's probable cause to believe the defendant committed even all of the crimes they're charged with, you still have the discretion to overrule the prosecutor and say, hey, all those wobbler crimes that you charged as felonies, they should actually only be misdemeanors going forward. They have the discretion to do that. So what happens in that scenario? Because the answer to that question is where we get to the interplay between Section 17B and Section 1001.95. Section 17B5 states that once a judge rules that the defendant is held to answer on misdemeanors only at a preliminary hearing, meaning they've heard the evidence at the hearing and they've determined that all of the offenses are just misdemeanors, not felonies. If they make that determination, then the case proceeds going forward as if the defendant is now just being arraigned on a misdemeanor. So the case continues along the path, the general trajectory of a misdemeanor case, assuming that you're only held to answer on misdemeanors. Now, if there's still any felony charges left over, then you're not able to have this conversation on this subject. But if the judge holds the defendant to answer only on misdemeanors, then the case proceeds from there on as if it's a misdemeanor. So then what happens? Well, that's where we get to Penal Code Section 1001.95. And under that section, as again, you might know from other videos, when you're facing certain misdemeanor charges, you can file a motion or a petition before the court saying, hey, the judge should exercise their discretion to suspend criminal proceedings and give me the chance to earn a dismissal through something called diversion. And so that can be quite a big windfall, starting the case charged with a felony and then getting yourself in a position where you just have to complete a certain set of terms and your case gets dismissed, going from something really, really troubling to something that's not so bad. It gives you a pretty clean bill of health, as we might say, when it comes to your criminal record. Now, a lot of things have to go right in that situation. You have to first win your argument at the preliminary hearing that you should be facing misdemeanors only, and then win the argument that your case should be diverted. Sometimes that might be a little bit too much to ask, depending on where you're at and what type of case you're fighting. Perhaps if a judge reduces the case to a misdemeanor at a preliminary hearing, another judge considering the case for diversion might think, okay, this is a misdemeanor, but it seems too serious of a misdemeanor to actually grant diversion. But it can happen. The important thing to know is that when a judge at a preliminary hearing forces the case to be a misdemeanor, the case proceeds freely as if it's a misdemeanor thereafter. And that's what allows you and your lawyer to file the motion for diversion under 1001.95. I emphasize this because one thing that commonly comes up in some cases that are Wobbler felonies is the DA might come to you and say, hey, we're charged with a felony, but we're going to offer you a misdemeanor right now, as a sort of tactic to get convictions and convince the defendant to plead. In that scenario, yes, you get the benefit of a misdemeanor, but it's still a conviction because you're only getting the misdemeanor with the DA's cooperation. When the judge forces the case to be a misdemeanor without the DA's cooperation, it's a whole different ballgame. And we can see that 17B and 1001.95 have a certain interplay, because if the judge forces the case to be a misdemeanor, you're not found guilty of anything yet. And so that's what allows you to bring the petition under 1001.95 to get diversion in that scenario. Like I said before, a lot of things have to go right for this plan of action to happen, but it can be done. In fact, we've done it before. So if you have a situation where you're fighting a felony and you think there might be a pathway to diversion, maybe it's perhaps overcharged or something like that, by all means, talk to good, competent representation and see what your remedies are. You might be able to get a better outcome than initially thought. Hope this was helpful. Thanks, and stay safe out there.